Thank you for being here. I am Ray Dickey, and our topic today is secrets attorneys want boards and managers to hear. Secrets. It may not really be a secret. It may just be something that maybe the attorney would have mentioned unless you asked. I don't know. Secret sounded pretty cool, but maybe there will be some attorney secrets. I have no idea. We will see. Before we go any further, I am going to launch a poll. If you are here for CEUs, click which one you need. Maybe you need more than one. It's okay with me. Depends what state you're from. Everyone has a question feature. That's how you communicate with us today. If I end up closing the poll before you have time to fill out the question feature, use that question feature and just say, hey, Ray, I need CEUs. If you are in Florida, you're going to have to do something extra. Cory, why is Florida so difficult? I don't, with everything. Just extra work for everyone. So is it because the weather's so nice during the winter and you have to?
During the winter, it's been raining here every day, so the weather hasn't been very nice lately.
All right. So if I ended up closing that poll for you, time to fill it out. Like I said, everyone has a question. Send me questions. Send me comments. I get so bored. I get so lonely. I start to daydream. And I just feel like no one likes me if I don't get any questions or comments. I don't use people's names, so feel free to ask whatever you would like to ask. If you want to know where John's doing his live stream from today, I know it's a different spot every time. Please feel free to ask. Really quick, I want to thank everybody that was at the expo in Somerville. Dawn, I thought it was terrific.
It honestly, one of the best. It really was. The Somerville crowd, Charleston crowd really showed up. And, with active participation, those events really just become something else. And the more people show up, obviously, the better it gets. So we can continue to hold those events.
And I want to thank National for being there also. Emily from CI National was there, and she is absolutely terrific. And we had a great party, and everyone stayed afterwards. Kevin, I'm sorry we didn't invite you.
Maybe next time. I figured it's just because I didn't wear the earphones on your broadcast, but okay. We'll see.
All right. Well, I was praising Elliot for his earphones earlier. Later today, we're going to have a bunch of managers on, and we always kind of go with whatever comes up. But I always like to throw a little topic in there. We're going to do an open door policy. An open door policy doesn't mean anybody can come in whenever they want and talk to whoever they want to. So I think this one is a lot of great advice on how to have a proper open door policy. Lastly, October 21st is the Hudson Valley CI Expo, and we're having a party this year. Deb, give everybody one reason why they should go to the Hudson Valley Expo.
Well, I think it's because we always make it fun. We want all people to come out, meet all the vendors, meet all the boards, meet all the managers, and just have a good time.
And it's going to be very interactive this time, and there's going to be different colored ping pong balls that you're going to have to do something with. So that's all I can say about that for now. I'm really sorry, but you should go, I think, and we're going to have that party afterwards. So I think it's going to be awesome. All right, we're finally at the point with our panel, and I see Stacey first. Could you introduce yourself?
Hi, everyone. My name is Stacey Patterson. I'm a community association attorney for the past 25 years. I am with the law firm of Ansell, Grimm, and we are located in New Jersey, New York, and Pennsylvania.
One thing about Stacey, she has a giant wagon that she brings to events. Do you agree, Stacey? That is the biggest wagon I've ever seen.
Yes, I will agree.
Okay. John.
John Legumina from the Legumina Law Firm in Purchase, New York. We represent condominiums, homeowner associations, and co-ops from New York City throughout the Hudson Valley area.
I have nothing to say about John that I haven't said already, except that he knows everything about the law. Everything. There's like nothing he doesn't know. So does everyone on here, but really, John really does know everything. Kevin.
Kevin Herzl, managing member of Herzl Law. So we represent over 1,000 community associations all over the states of Michigan and Illinois. Glad to be here, Ray.
Kevin denies that he takes multiple naps during the day. He's a very fancy person. He has a very large practice. I don't believe him because he's always cheerful and full of energy. Kevin, are you sticking with that? Do you not take any naps?
Sticking with my story, I don't have time to nap, right? Yeah, I spend too much time preparing for live streams, writing books, vacationing in Italy, with John. So, just don't have time to nap.
Okay, there was a lot there, but thank you. Deb.
Good morning, everyone. Deborah Gerelli. I'm the Vice President of Gerelli Insurance Agency here in Cold Spring, New York. We have a department dedicated to community associations, and we also are a full-service independent insurance agency. So we can help with all of insurance needs for your contractors, your homeowners, and your associations. Glad to be here.
True or false, Deb? The Gerellis love snow. You love to play in snow as a family. True or false?
Yes. Love snow.
See how much I know about the panel. People are asking me where Adam is. Adam never misses live streams, but he had a last minute emergency that he absolutely had to take care of. So that's why he is not here. Cory.
Good morning, everyone. My name is Cory Kravit. I'm the managing principal for Kovitz, Shifrin, Nesbit's Florida office. We're based here in Boca Raton, Florida. We also have offices in Indiana, Illinois, and Wisconsin.
Cory, have you ever captured one of those giant iguanas? I see that. Or has a boa constrictor ever attacked you?
I've caught many iguanas. They sometimes they swim in my pool. They're all over my backyard. The dogs chase them, but I have not seen any boa constrictors.
Okay, that sounds like actually like fun. Dawn.
Hi, everybody. My name is Dawn Becker-Durnan, and I am an insurance broker, independent, just like Deb Gerelli. We provide insurance products for community associations all across the country. We are a national insurance agency. I also happen to serve on CAI's board of directors. Oh,
Elliot?
CAI South Carolina, sorry.
Okay. Elliot, you may not know that Dawn has numerous pets, including parrots and dogs, a cat, and 2 boys that run around like a maniac on motorcycles and the like. She may be the terror of the neighborhood. I'm not
Well,
sure.
it's homecoming right now, Ray, so we're preparing for that.
Okay. Elliot.
I'm Elliot Engstrom. I'm an attorney at Sellers, Ayers, Dorset, Lyons. Our office is in Charlotte. We represent community associations throughout North and South Carolina.
Oh, right. And all I know about Elliot is he has 4 kids. He's keeping a lot to himself because he's aware that I'll use it during the live stream. So Elliot will be hopefully on our live streams for a long time because that's a lot of kids to pay for. All right, I'm going to launch a poll. This question came in before we get started, and I did want to get to it because people were interested in it. I hit the wrong button, so give me a second. Should a manager have to respond to residents in arrears for non-emergencies? Let me poll the audience. And because somebody sent that and they were so nice to send it, and I just never got around to making it happen. So let me give that a few moments to come in here. Should a manager have to respond to residents in arrears for non-emergencies? And I want to make this quick because this is not our topic for today. And if you can't do it quick, just say, you know what, Ray, I can't do this one quick. I am going to end the poll very, very quickly, and I'm going to share the results. So 88% said yes, that they have to respond no matter what. Stacey.
I agree.
John.
Agree.
Kevin.
Absolutely. They're probably trying to pay you anyway, so respond.
Cory, devil's advocate. They're not paying their fees. They're in arrears. I want to call the manager and I want some information, or I want them to do something that's not an emergency. Do they have to still help me?
Yeah, the payment of the non-payment doesn't affect the duties of the association to provide whatever services they're required to provide.
Elliot.
I guess the only devil's advocate argument I could think of is if the association has suspended privileges in accordance with the declaration and they're saying I want to exercise my privileges and you've gone through the right process, maybe, but I still think you need to respond.
Elliot,
it's not the answer they want.
I love devil advocate aspects. I absolutely love it. Stacey, I'm getting feedback from you, so maybe like mute and unmute today. It's not your fault personally. Sometimes it happens with the equipment. So, but I could see it. So just there you go. All right. Secrets attorneys want boards and managers to hear. So I'm just going to get the ball rolling with one that I came up with, and then I know which attorneys have them, and some I'm going to go with mine. Harassment claims don't require intent, just perception. Harassment claims don't require intent, just perception. John, commentary. Is that true or false?
I'm going to say that's false. So there's in New York there's criminal harassment. Part of that is you do have to have there is intent. Now, importantly, associations can't enforce criminal law, so that would have to be the police.
Okay.
Civil harassment is kind of that's a real vague term, and I don't even know if it's actionable, but you know, for condos and HOAs, you could warn and fine if someone's being a nuisance.
I was thinking like sexual harassment, Kevin.
I'm going to go with true on that, just because there's hostile environment claims under the Fair Housing Act, which is becoming a big thing. And a lot of those cases, they're very fact specific. And so the jury is going to decide whether somebody had intent or not. And I think a lot of times that ends up, based on perception and their interpretation of a he said, she said factual situation.
Cory, where are you with sexual harassment in Florida?
You would have to have intent in Florida for sexual harassment. Obviously, on the quid pro quo side, if it's if it's more of a workplace one, intent, it might not be the strongest of intents, but I still, it depends on a case by case basis. You really can't answer 100% true or 100% false on a question like this.
Elliot, I've never met Kevin in person, but I know I just want to hug him. Not in a weird way or anything, but he's so famous and everything. But maybe you're an overhugger, Elliot. You're the manager and you just hug everybody. And somebody files a claim of sexual harassment. Intent? You didn't mean to do it.
I guess we're operating under the Fair Housing Act there, like deprivation of or discrimination in housing on the basis of sex. Normally, when I think sexual harassment, I think of employment Title VII, but I do think that you have to. I think if you show that the environment is a hostile environment, even though it's like, well, I didn't mean to, then that's a problem. I do think that if we're trying to mitigate claims, we're generally going to be really conservative in how we advise our clients, because even if we say, yeah, you can go hug people and you probably win if you get sued, well, we're trying to help you not get sued, right? So we're going to be really conservative in how we advise on those situations, and we probably say maybe stop hugging everybody if it seems like it's becoming an issue.
Okay, Deb, very quick, insurance. Will you be covered or not covered if you are, let's say you're a board member and you're an overhugger and someone complains and files a lawsuit?
So yeah, you got to make sure you're buying the right policy, because harassment can be covered. Obviously, they're going to cover the defense, but not any kind of, it's potential that they won't cover any kind of monetary judgment that comes down. Usually they're not, so yes, but it's with the right policy.
Dawn, any additional commentary?
I think we have to be very mindful. Sexual abuse and molestation is becoming a very big exclusion with a lot of our insurance carriers on the general liability. Same with the assault and battery. So as Deb pointed out, it's really about coverage and paying attention to what you're buying.
Someone says that I should ask Kevin for permission before I hug him. Kevin, if I meet you in person, do I have permission to hug you?
Just for you, Ray, but nobody else.
I noticed that you hesitated, which made me feel very icky for some reason. Like you're not really sure if I'm joking. Okay. Well, thank you. Anyway.
I can say I was not expecting that question, on the live stream today. So you did catch me a little bit off guard.
Okay. All right. Let's start with the person who has our first secret. All right. Cory, what is your secret between us, you and I, and no one else except listening?
Don't tell anybody. But one of the things I find out from my board members is they always ask me to send cease and desist letters and they don't realize that the cease and desist letter really doesn't have much teeth. Either the person's going to comply or not, but some people think it has special powers like a trespass warning, and it really doesn't. We try to make them strongly worded to persuade people to follow it, but if they don't, in order to stop them from actually doing it, you may need a court order.
I remember, was it you mentioned that a lot of people just ignore them, throw them away? They don't care.
Sometimes they do, and sometimes people think, like I said before, they have these magical powers that, oh, I better stop, or I'm going to go to jail or something. I was just on the phone with a client a couple days ago and explaining that, we're happy to send a letter, but we can't guarantee that people won't follow the demands.
John, commentary on cease and desist letters. Any additional commentary?
No, I have a similar experience with Cory. Maybe, the idea is maybe you get the people to stop, but more times than not, they don't really accomplish too much other than escalating an already rough issue.
Kevin, do you write them extra mean to old ladies to terrify them?
No, I mean, typically what I find where boards get confused is they don't understand the difference between a cease and desist letter and an injunction, and they think that they're exactly the same thing going to court, and they're equal, but they're not. So I completely agree with the panel advice. But with the little old ladies, I tell them if they don't comply, I'm going to send Ray Dickey out to hug them, and that usually gets them, in line.
No, they would little old ladies like me because I'm very nice to them. Cory, cease and desist letters. Any additional commentary?
I'll try not to send them to the little old ladies because they'll come after me with their canes and they'll beat you with them.
Okay, Elliot, cease and desist letters.
As everybody said, I run into the exact same issue. I think really one of the most important functions of a cease and desist letter is just to document that there is a problem and the association is saying there is a problem. And I'll actually put that in my letter sometimes. Like, part of the purpose of this letter is to make sure you are aware that you are in violation of the documents.
And by the way, audience, I'm looking at the questions over here, so just so you don't think I'm staring off into space. Do you have to notify the insurance company if the association gets a cease and desist letter? Dawn.
Yes, I would, because it's a notice in a sense of circumstances that could give rise to a claim. And any type of legal letter is an actual item that should be reported to the insurance carrier. And directors and officers in particular is often written on a claims made basis. So not reporting it can be absolutely detrimental to your coverage.
Deb, I was surprised by that answer, but I usually am. A cease and desist letter, does it matter who it comes from?
It doesn't matter who it comes from. It's something against the association, and therefore you should actually put your carrier on notice of the situation.
Quick, I want to do these quick from the audience. Can a board send a cease and desist letter? I know anyone could send one theoretically, or should these come from attorneys only? Is it safe to assume, panel, that if you're on the board or a manager, you should have your attorney write the cease and desist letter? Anyone disagree with that? Any additional commentary needed? Or if I was an attorney, would that have sufficed?
I would say a lot of boards and managers will send a courtesy letter first. So that's pretty customary. And I would say before it escalates, that's kind of a good way to resolve it. But if you're kind of at your wit's end and you really want it resolved, you get the attorney involved.
Okay, yeah, so go ahead.
I agree with Kevin. I think it's a better practice to have the managing agent or board send a warning before you ask an attorney to get involved.
Yeah, we don't have time to get into it, but I wonder what the line is between a warning and telling somebody to stop something and a cease and desist. Can you give me a quick answer, Cory?
I think generally the association should try to use sugar to get what they, the desired effect before they turn it over to us to use our salt.
Okay, so what you're saying is the association just be very, very, very nice and then save the hard line for your attorney. Yes?
Let us be the bad guy. Mm-hmm.
Okay. Next one up is Stacey. We are ready. Not a personal.
I forgot that I was even part of this panel. Unbelievable.
Oh my! You know what, Stacey? You know what? I apologize. the way my screen is,
Okay.
I apologize. Cease and desist letters.
No,
though.
that's totally fine.
Well, no,
Am I
so-
still getting feedback? You still getting feedback from my?
No,
Can
you're
you hear me?
fine. Yeah, that's what
Okay.
threw me off. Go ahead.
So I don't know if it's much of a secret, but I know it's not, it's something that comes up a lot because my clients' boards will tell me that before they refer a collections matter to us, they send multiple letters to owners demanding payment. And what they don't understand is the more communications they send without the federal protections will subject them to the Federal Debt Collection Practices Act and will force them into a category as debt collectors, which is what the Federal Debt Practices Act covers. And that's why I always recommend to them that they should never, or I mean, they can send one letter, but they should not give the idea that they're holding themselves out as debt collectors because they'll be held liable under the federal law.
So if I'm hearing that right, this is very interesting. You're not subject to that because you're not a debt collector, but if you send too many letters, you could put yourself in the realm of being considered a debt collector.
Correct. And debt collectors have very stringent requirements when they send demands for consumer debts, which collections of assessments are. So there's certain language that needs to be included in the letters and in even in phone calls, emails. There's always language, but our clients, our managers, and our board members are not aware of what that language is. And if they continue to send, like for example, I'll get somebody to say, we sent this person 3 letters and we've been knocking on their door and we've been calling them, and I say stop.
Okay.
Because you're going to get yourself in trouble. You should direct it to us.
Super interesting. Never knew it. That is a really good one. And I know, and I passed you a couple times. I'm sorry. John, commentary.
Well, I mean, I agree, like it happens. So I kind of agree with Stacey. I don't want to comment more, but New York, it's pretty much the same.
Okay, Stacey, why don't you mute because I get the feedback when you're not speaking. Elliot, commentary.
Yeah, I think Stacey makes a really good point. I mean, when we're looking at what the association sent, we're mainly trying to make sure they've sent the notices they're required to send, under the statutes and the governing documents. But we're not going back to them and saying, hey, send 5 more letters, then we'll go. So I think she makes a really good point.
Cory, I think it's a great point. I've been doing this for 5 years and not one attorney has told me that. Cory, any additional commentary?
Yeah, Stacey makes a great point, and there's not, some states will, or I think most states will also have a state version of the Fair Debt Collection Practices Act also, which is often less stringent than the federal. So it's in Florida, it's actually easier to bring a claim against a management company under the state act than the federal act. And in Florida, the association is also required to send a notice of late assessment letter prior to sending it to us also as one last attempt to collect the assessment before attorney's fees are added. So there is but the state does give you a template of what that letter should say.
I'm just going to go with a question for you, Kevin. You can add commentary if you need. It's
Sure.
related. Is it the same if, say, the HOA is acting in good faith, meaning like they sent the initial collection actions, however, they were trying a last effort, like, hey, we will waive fees or work with you. I don't want to get into a whole topic on collections, but go ahead.
So number one, the easiest way to prevent any issues is just to have the association adopt a collection policy, and then it goes through that collection policy. Everybody's treated the same, and you can draft it so you don't run afoul of these laws. Number two, typically, at least where I'm at, this is more of a concern for management companies, debt collectors, attorneys. Associations, at least under the federal, are typically exempt from being a debt collector because you're allowed to collect your own debt. But I do see a lot of state law claims that arise out of this, and then certainly with the management company, depending on what activities they're involved in. So that's typically how I see it play out in our jurisdiction.
All right. So let's do. Oh, okay. Somebody's asking me to do Elliot. So let me find Elliot. Elliot, looks like you have a fan out there. Okay. Is it your mom or be honest?
I mean, maybe, honestly.
Okay. Elliot, what is your secret?
So one issue that boards and managers come to me with a lot is they'll say we have board members come into meetings and being unreasonable and arguing with us and talking back to us and saying things we don't like. And obviously there's a line where you can't just let your meetings be hijacked. But one thing I tell boards a lot is that if the impulse is to immediately shut people down when they're being unreasonable and rude, I tell them it's kind of like a steam valve. There's actually a lot of value in letting those people talk, especially at a board meeting or a members meeting, because one, people who are heavy critics of the board want to be told, be quiet, because they will say, you can't take the heat. You guys can't take the heat, and if you just let them talk, you say, thank you for your comments, you are deflating them. The other issue is that especially at a members meeting, you can't let a person hijack your whole meeting, but there is value to letting everyone else in the association see what you are dealing with. And so I would just encourage boards to, within reason, when people stand up and want to criticize the board, let them talk for a minute. Just let them criticize you. And that's in response to requests I get from boards that say, how do we get this guy to stop talking? I just think there's a lot of value in being a sponge for a little bit, letting them have their say, and then say, thank you for your comments.
Kevin, I love it. I've been saying it for years. If you want to really upset, I'm going to be not as nice as Elliot. If you really want to irritate these people, just dismiss them like a 3-year-old. Like, would you respond to a 3-year-old and let them make their comment and just go to the next one? Like, it didn't even mean anything. That'll just irritate the hell out of them. Elliot, I don't think that was the purpose of your intent. I just want to go back to you since I kind of took your idea and make sure I didn't confuse it with what you said. It will drive them nuts, those people.
And the goal is not to drive them nuts, but the point is some of these people, and again, some people have legitimate criticisms of the boards, right? But some want to be told be quiet because then they say, the attorney's trying to get me to be quiet. They can't handle the heat. They just can't handle it.
A lot of people, Kevin, want to drive them nuts. Thanks, Elliot. Also, commentary, Kevin.
So no, I agree. I think that's great advice. Certainly, I mean, when I was younger, an attorney, I used to kind of fight the fire with the fire. But that ended, at least one time with me getting chased in a parking lot after a meeting. Maybe they were just trying to give me a hug. I don't know. But I would say as I've gotten older and wiser, I agree with Elliot's strategy. And I do think it's effective. A lot of these times people just want to be heard. So I think that's great advice.
Stacey, any commentary?
Yes, I also agree. However, I also believe that the board is responsible for maintaining order in the meeting. So if somebody is, being attacking of the board, first of all, I think it should be reserved for the end, and they should be told if you have questions or comments to wait till the end of the meeting, or else you're never going to get any business accomplished. But also, if it crosses the line from attacking words to, maybe physical, at that point, I think it's necessary to either shut them down or close the meeting because you're not having a meaningful meeting to conduct business. So it really depends on the circumstances.
John, the scenario is somebody's just talking on and on, but not super long where they disrupt the meeting or it's absolutely ridiculous. The commentary is just let them talk it out and whatever, and just go on from there. Agree, disagree, commentary.
Yeah. I mean, I agree. Deflect. Thank you for your concerns. We'll take it under advisement. Is probably the best approach to take. Obviously, if it's getting ridiculous, Stacey's right. Like you can't hijack the meeting, and there is a protocol and questions to be for the end, and you shouldn't let one person dominate. And
okay, right.
It's out of hand. But I agree. Deflect, take it under, and you should let the person say it, whatever, even if he repeats it all the time. Let him say it if it's not taking too long, and you'll consider it.
Cory, I think I'm being honest here more than you guys are, and a lot of board members hate these people. They're very disruptive and they annoy the heck out of them, and they do want to make them look bad. And I think the fact of just ignoring that is not really fair to our industry. Also, I don't know why board members have to say thank you for your comments. If somebody sits there and says you're a jerk and you're a crook and I hate you, Why would you say thank you for your comments? Why couldn't you say, okay, we've heard your comments. Let's go to the next person. Commentary. Am I just a mean person, or do other people think this?
The common
I have a
issue is that
comment.
boards will spend more time fighting either with themselves or with members of the community than actually getting work done. You're there, it's a board of directors meeting. You're there to get work done. You're there to speak to other board members. And what I found, especially in hot situations, is prior to the meeting, if you explain how the meeting works, sometimes this is the first time that people have gone to a board meeting and they don't know how it works. If you explain to them the process, explain to them the agenda and when they'll be able to sign up or say their piece and for how long, and I'll stand there with a timer. When they hear the beep, 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 they know they got to stop talking and move on so someone else can have that ability.
Yeah, that only works if they're not crazy, and they're insane. So, Stacey, you had some commentary?
Just really quick, I just think you asked why you should say thank you for your comments. I mean, I think that all eyes are on the board with how they respond to this person. You're in a leadership role, and the other owners who are there are going to look to you to see how you respond and whether or not you are a person that should be leading this community.
I would only say, and then I'm going to drop it. I think saying thank you is very insincere when somebody stands up there and insults you and accuses you of being a crook. But that's me.
Kill them with kindness. That's what I say.
Okay. Dawn, quickly, any commentary?
Thank you for your comments, Ray.
I have an industry secret. If you have
Wait, I don't want your secret. We're gonna go to you guys.
It's
Any
not
commentary? Any commentary on this secret?
Yeah, if you the behaviors, if you bring your insurance brokers to meetings and we witness that and we have to sit through those meetings, you might have your D&O canceled.
Wow, that is a great one. You should have saved that for a secret though, because I'm going to go to insurance secrets. That's a really good one. I didn't know that. Deb, any commentary on this secret?
I kind of agree with everybody in one way or another, but you really need to be, if you're the board, you have to control your meetings. You can't just let them get out of control and have people yelling and screaming. There has to be, control from the board.
Are you saying you agree with me a little bit, Deb?
Actually, Ray, I do. I
Okay.
try not to say thank you to somebody who's being insulting, but I do say I've heard your point and we'll take it under consideration.
Because I was feeling bad about that. Okay. All right. So don't mess with Deb and I. We're not saying thank you. The heck with you. All right. Let's go to Kevin. Let me see if I could find Kevin. Kevin, by the way, audience, Kevin had a million secrets. We just need one. And it's just so hard for him to choose. Kevin, what did you choose?
So the secret I'm going to go with is for the management company and the boards is don't try and draft the rules yourself. So I see a lot of times, if it's a document amendment, they'll go to the attorney and say, this is a big deal. There's going to be procedures. We need to have this formal vote. And a lot of times they won't want to spend the money and they'll try and do it themselves. And so what they don't realize is that they've either drafted a rule that conflicts with their governing document, which is something they can't do, or there's this whole host of statutes out there, whether it's something like the homeowners solar energy policy, the FDCPA that we talked about before. In Illinois, we have this wonderful Native Landscaping Act about what kind of flowers you can put in your front yard. All these different things. We have accessible parking. They require very specific rules. And a lot of times, even pool rules, for example, people will try and ban kids, if they're under 14. Which could create an FDCPA thing and as a common sense thing. So, kind of the way that I see it is if you're going to draft them, at least have the attorney check them, because I see a lot of people kind of, go off kilter there, even though they're well-intentioned.
Thank you, Kevin. Elliot, who would draft their own rules and not check with their attorney? That sounds like the worst idea ever.
A lot of people, all the time.
Any commentary?
and it's not a good idea. My commentary is that I think I see boards of managers do this sometimes because they think they're saving money. They think we're going to draft it, we're going to send it to the attorney. The attorney will tweak through things and move on. It often takes me longer to go through a association drafted document than it is for me to just start from scratch, because I may have done something similar for another client. So I would check with the attorney first, say, here's what we want to do, and let the attorney draft the legal documents.
Cory, anything to say that that hasn't been said already?
No, I usually ask my clients, send me a wish list of what they're looking for, and then we'll provide the language like Elliot mentioned. It's much easier.
John.
Yeah, so I agree with Cory. I said sometimes to help, I'll say, hey, I'll send you some bullet points. These are the general areas. You check, you say yes or no, and then I'll figure out the language.
Stacey.
I agree with everything that everyone said.
I love it. I love it.
I love it.
Okay. And I just heard myself say I love it like 3 times from your mic, and it made me sound really weird. Okay, let me see who hasn't gone yet. John has not gone yet, and I got to bounce around and find John. Now, John, you're going to go with one of my secrets. Did you still want to do that? Okay.
Why not?
A board silence can be as dangerous as a bad decision. Ignoring something is still a choice. I think there's a misunderstanding with this. John, true or false?
It's true. I think Dawn and Deborah will back me up on this, but classic example is we had a leak, you knew about it, and you didn't do anything. And that's going to expose you to, so, you know, most boards, you have the responsibility to promptly repair common areas. But that doesn't mean you're a guarantor that there'll be a leak. But when it's brought to your attention, you need to check it out. And importantly, you need to actually respond, even if it's, you know, schedule an inspection, have an inspection, and not being able to figure out where the leak's coming from. That's better than no action.
All right. Elliot, I want to make it a little bit more complex. I want to make it like maybe you know that there's a hoarding situation and you walk by the unit all the time and you're a board member and you don't say anything. You know, but maybe you told some people about it.
Well, the board does have an obligation to enforce the governing documents, but I'm going to give a very lawyery answer and say it's going to depend on what your governing documents say. Because if your documents don't give you authority to do anything about hoarding, then you're not making a mistake by ignoring it. If your governing documents specifically say hoarding is, you know, prohibited, and here's what hoarding is, and you just let it slide, at best, you're going to lose the ability to enforce that restriction. At worst, somebody could potentially sue and say you guys are not enforcing the documents in the way you're supposed to.
Let's see. Stacey, this one could be tricky.
Well, I think that it really has to do, I always tell my boards that you have to act in the best interest of all the owners overall. And in a hoarding situation, especially in connected units, if you don't do anything, you will likely affect the other neighboring units and common elements, which will basically be detrimental to more than just the hoarder itself. And things should be taken into consideration for everybody else's safety and well-being, especially if you don't even know if the person's in there or not, and if their health is in jeopardy. I mean, I think that they at least have the obligation to go in and check to make sure.
Cory, I wish we could come up with a more complex scenario, one that's more on the line, more on the border, more in the gray area. Can you come up with one? If you can, it's fine.
I mean, listen, at the basic essence, the job of the board is to maintain the community. And if you're not maintaining it intentionally or for whatever reason, you could go from negligence to gross negligence to intentional misconduct and lead to a breach of fiduciary duty. So sometimes your right to remain silent isn't always the best option, especially when you have a duty to maintain.
All right, Kevin, last word on this before I go to our insurance people. Stacey, thank you. Kevin.
So I'd say don't be an ostrich. You can't put your head in the sand. If you know there's an issue, especially if there's going to be some kind of a negligence claim, a jury is going to look at this and allocate fault. And if the best you can do is come up with the defenses that we didn't do anything, they're really going to wonder whether you fulfilled your fiduciary duties in that circumstance. So I do think you want to document every time you're aware of some kind of an issue, some steps you've taken to protect yourself, so you don't have to file an insurance claim.
Why did you pick on ostriches? That seems discriminatory. I will tell you right now.
Because I knew that was the only kind of bird that Dawn didn't have, and so I thought I was safe doing that. I wasn't going to get any pushback.
Yeah,
I must have offended her. She just left the live stream, so
she
I
actually
apologize, Dawn. I did not mean to pick on ostriches there.
She sent me a text and she said, "I've been doing these live streams for a year, and this guy Kevin is just irritating the heck out of me. I'm leaving."
I didn't mean to offend you with my ostrich comment.
No, Dawn did not. She did not say that in any way whatsoever. She did text me. All right, I'm gonna go. Well, let's catch Dawn really quick since she's back. Dawn, okay, so I've hit all the attorneys, I believe. Dawn, any commentary? What would be an insurance secret? I love the first one you brought up, but do you have another insurance secret?
Yeah, we know everything, and the insurance carriers, they know everything. So if you've had a claim, and even if it was 10 years ago, they know about it. And there's not that many insurance carriers, and you keep going from one to the other, we know. And so those type of things, a lot of the boards and their managers think that they're in secret and going and doing these things, but transparency is so important. And when that doesn't happen, it's a really poor reflection on the board.
Okay. Deb, do you have like an insurance secret that you wish people knew about insurance in our industry and nobody asks or doesn't think about?
So I feel that a lot of times boards tend to get upset with insurance companies when they go and settle claims quickly, meaning liability claims. Like, wasn't my fault somebody got hurt on my premise. Why are we paying out on this claim? Well, what the boards sometimes don't understand, there is a duty to settle clause provision in the policy, and the insurance company is really doing it to protect them and make sure that the judgment is not more than their policy limits, which could be detrimental to an association. So that's something I deal with a lot, boards getting upset that insurance companies are settling claims when they didn't think they did anything wrong, but it is actually in the policy.
I love it.
I love it too, and I'm glad that, Deb, I just want to piggyback on that. The other secret that I don't think a lot of people also realize is when an insurance carrier says we're going to tender our limits or pay the policy limits, there is no longer a duty for them to defend.
Okay, now you're getting into 2 minutes. You're like Kevin. You're getting too excited. You want to do too many secrets. And by the way, Dawn, you love insurance so much. What I was going to say, not that I love like insurance comments so much, I was going to say I love the comments and the secrets I've heard because I could use them for new topics, but you love insurance so much, you just assumed that I was like so excited about the insurance comment that I was like, I love it, because you love insurance. True or false? You do love insurance.
I do. I'm very passionate about it.
Deb, you love it too. You wouldn't have your CIRMS.
Yep, very passionate about it.
Yep. And I think all the attorneys probably love the law. Maybe. I don't know. I'm not going to put them on the spot. All right, let's now, usually Jennifer's here to do a giveaway. She's not here, so we'll just do the poll question anyway. Neither is Tom. Kevin, the way we do this is, I don't know, like 98 people registered. There's like 74 here right now, but I'm going to pick A, B, C, or D. That'll be a number at random, and that's who would be playing for.
We're going to play for A.
We're going to play for A. So that's going to be number 3. So if you're number 3 on the registration list and you are here or who's ever close, you will win a prize, and I will have Fusion get in touch with you. If you miss Tom Ingblom and you want him to call you, I'll set that up too, but that's completely up to you. All right. Now you have to guess, Kevin, how the audience is going to answer. Okay. So I'm not going to hit the poll yet. And the question is, if you could read other people's minds, would you? Now don't say anything yet, Kevin, because you're the final word. Very, very quick, panel. Stacey, if you could read the other people, I'm not asking you personally. You could answer personally if you're comfortable, or the audience. If you could read other people's minds, would you?
No. I wouldn't want people reading my mind.
That's scary. John.
It'd be hard to resist the temptation not to.
I would love it. Deb.
So I would say yes.
Cory.
Yes.
Elliot.
No.
Dawn.
I don't want anybody to read my mind. Oh, no, I don't really want anybody to know. I don't want to know what they're thinking, but I want them to know what I'm thinking.
What?
I want them to know what I'm thinking.
She wants
I don't
it to
wanna
be a
know what
one-way
they're thinking.
street, not a
That
two-way
sounds
street.
insane. Why would you want everyone to know what's on your mind all the time?
Because there's a lot of F words in there.
What? All right. Okay. So audience, Kevin, just think in your head which way you're going to go. And I'm going to poll the audience now. Okay. We'll just trust you. Audience, go ahead. If you could do it quickly, I would appreciate it. If you could read other people's minds, would you? I know I would. I think it'd be upsetting. I would probably have a breakdown.
So I bet you I'm going to be able to read the audience's mind in doing this, Ray. So we'll see.
Well, you should have already guessed by now, but we'll see, because you're seeing the results pop up as they come along. I think I could read some of the panel's minds sometimes. You know what I mean? Like John looks like he's just ready to, like, he needs to do something else. I could just tell. He's always great to be here, but I could just tell he's got a lot of stuff coming up. Okay, here we go. So I'm going to end the poll, and the results were 62%. Oh, wow, not pretty even as far as our polls go, but 62% said yes. So Kevin, what was your decision before you sold the poll?
I was going to say yes. I think the most people out there would be like John, and they just couldn't resist the temptation.
So that's a winner.
For me, like, knowing what my wife is thinking 100% of the time, I mean, that would be a gift, so.
I think I have a terrific wife, but I think she's telling me what she's thinking all the time, 24 hours a day. Dawn, you've said many times my wife is so lucky to have me. You're constantly telling people that every time I see you. So
yeah, she's wonderful. She's very much sociable and
Dawn.
Oh, I could go on about Michelle.
No, we're not looking. That wasn't what I said, and we're not looking to do a whole thing on how great my wife is, which she is, but that's very kind of you. Thank you. Okay, so let me do this right here. Let's go to some of the questions I have, because I've been kind of saving them from the audience. And let me find my slide here. Okay. I'm just going to read them as I see them. And I don't want to spend like a tremendous amount of time on them. But can a board still be held liable if they know of an issue, but they do not have the funds to fix it, and a special assessment has not been approved? Boy, that is a big one to try to get done quickly. Stacey, very quickly. If you can, maybe you can't. Just say you can't.
I mean, I think that's something that you have to discuss with your attorney and your accountant, of how you can go about managing what you need to do while the limited funds that you have.
John, any additional commentary?
Yeah, so the answer is yes and no. Like, most places the boards have the authority to increase the budget and to pass a special assessment. So not having the funds is not a legal excuse for not doing the work. However, if you actually have to, if the owners have the approval power over the special assessment, then you're in a catch-22, because if they don't vote for it, then you're going to have a decaying infrastructure, and that's why you rarely see those requirements.
Kevin, I think we just did this as a topic. This comes up all the time.
Yes, I mean, there's actually a case in Illinois that says if you have, insufficient assessments or you don't fund your reserve properly, it's a breach of fiduciary duty. So I agree with John. If you're kind of in that catch-22 situation, at least hold the vote, and then I think you've done your duty.
Cory.
Especially if it's a life safety issue, no question, you got to get it done. You got to raise the money. If it's about, replacing a hedge or something that has a little bit more discretion, then I think, probably not.
So Cory, jump back in if you need to. Elliot, so you're on the board. It doesn't pass. It's a life and safety issue. So you just go out and spend the money anyway. True or false?
If you don't have the money, I don't know what money you're spending.
Well, you can borrow it.
If you, assuming the board could borrow money without member approval, maybe, but oftentimes there's member approval requirements. I mean, I would say I noticed the question is, can the board be held liable? I think if the individual board members are doing everything they can and they just can't raise the money, I think a claim against a board member is going to be tough. But the association has obligations, regardless of whether it has the money or not. So I think those are two different questions.
Cory, I just want to throw this back at you because I'm interested. You're on the board. You have the safety issue. Who cares what the governing documents say? Who cares? You got to borrow the money. You got to fix it. So the board goes out and borrows the money. Is that what you're saying a little bit?
I'm saying if there's a potential for, if there's
Yeah.
a life safety issue, you're going to have the duty. I'm sure the documents support doing that kind of maintenance or that kind of replacement. And let's say the board is split and 3 people say, no, we don't want to do a special assessment. And 2 people say, yes, we do want to do the special assessment. The association plus those 3 board members who voted no could be personally liable for a breach of fiduciary duty for not doing, if somebody, especially if someone gets injured, for not doing the work that they're required to do. Those other 2 people who voted no may have some insulation, at least from personal liability.
Deb, I heard breach of fiduciary and insurance.
Like you say, right? Everything has some kind of an insurance topic in it, right? So, right, breach of fiduciary duties is a coverage that is afforded under the directors and officers policy. But obviously, it's always going to depend on the specific situation and things that occurred leading up to that breach of fiduciary duty.
Didn't the board at Champagne Towers get sued, even though the owners kept voting no, raising assessments? Dawn, I'm not an attorney, but I think everybody got sued, and I think I did read that they all did get sued.
They did. And I do want to point out that we don't really mention this, but obviously intentional acts aren't covered, but accounting errors aren't covered by insurance. And that's something that we're actually seeing quite often, resulting in claims.
I don't want to get sidetracked, but I can't help myself, John. Can you just tell the, you're on the board, can you just quit the board? Can you just say, you know what, I don't agree with this, I'm out of here, even though it's a safety issue? Could you just quit and kind of, will that help you out?
Well, you can quit whenever you want. There's no nothing to prevent you from quitting. But if your exposure to liability up until the point you quit is still the same. It doesn't go away.
Oh my gosh, that's terrible. Okay, Ray, I think you have a valid point. We, instead of saying thank you, say we understand. There's a lot of commentary of the audience backing me up, going back about not saying thank you to people that are so unbelievably mean. Some people say, I will also ask sorry about that. I will also ask the complainant to join the board so they can implement their plans. That always gets them to back down. That is a really common one that comes up all the time, and they always have an excuse. Why not offer to meet with the complaining owner after the official meeting? We're always assuming that these people are normal people, and unfortunately they're not. Boards don't have to take questions if they don't want to, unless it's in their governing documents, and maybe it's their annual meeting. Attorneys, Stacey's making a face. Am I right or wrong, Stacey? Because that's a question
here. I think they have the obligation to at least listen to their owners and address the issues, because if it's possible that other owners will think that they have the same issues as well and want them addressed. Just because they're not speaking about it doesn't necessarily mean they don't have the same issue.
John, do boards have a legal, I'll change it a little bit, obligation to take questions if it's not in their governing documents?
No, no, they don't have an obligation to take questions if it's not part of their governing documents. Now, almost probably I would say 100% of the annual meetings I've been to, they do take questions at the end. So it's become the custom, and so I think if that's what you've been doing for 20 years and all of a sudden you just refuse to take questions, I think that opens you up to you're exposed. So yeah, so the answer, so I agree, you have to take the questions, even if the governing documents don't really bind you.
Kevin, I know boards that have come into play sometimes and they've just said, we're not taking any more questions.
Yeah, I'd say that's like, legally it's okay, but it's really the equivalent of giving them the middle finger,
right?
To everybody who wants to ask one. And then typically it snowballs into what are you hiding? And then the HOA rumor mill eventually snowballs until you have a legal issue.
Right.
And so to me, this is just a prevention tactic as opposed to a legal obligation.
Okay. Cory, legally, do you have to take the questions? Florida probably has a law, I'm sure.
You're right. Florida does have a law. It's not necessarily at a board meeting. It's called a written inquiry, And so if someone sends in a written inquiry, the association has a certain timetable to respond to it. And there's even a part of it that says if the association needs to consult their attorney, they have an obligation to consult their attorney to answer the question.
Elliot, what is going on? Someone is writing. I'm going to see if it's the same person. I can't check right now. Elliot has great points. Could we put a timer on a rant? Let's say 3 minutes. Who do you have out there? Do you have two fans, or do you think it's the same person?
It's either a plant that I put out there, or it's I did share with my firm that I was going to be on here today, and there's one attorney in mind who he's special, so he might be out there.
Okay.
Yeah.
But anyway, you could put timers, right? You could, obviously you can, or you'd be there forever, right?
Yeah, I mean, in North Carolina, there actually is a statute that says owners have to be given the opportunity to address the board at regular intervals, but the board can put time limits. So there is a legal obligation in North Carolina. But I agree with all the points from other panelists about the practicalities of if it's a good idea to let people speak in addition to that legal obligation.
Okay, I really want to watch our time, so I'm just going to go to Stacey on this unless anyone disagrees. Stacey, I love this question. Is sending a statement of money owed as a reminder viewed as the same as a collection letter request?
Well, I don't know. It's kind of a gray area. I mean, if you're not making the demand and it's being asked voluntarily, then arguably you're not demanding, money to be paid. So sending somebody at the request is not going to make them a debt collector because they're not trying to collect.
I love gray areas. Thank you, audience, for sending it in. I love it. Okay, I love gray areas. I do love insurance, but not as much as Deb and Dawn does. All right, let's do any attorneys want to comment on that? Because I want to have time for closing thoughts. Okay, excellent.
Really super fast. Bankruptcy violations, even like just any statement could be deemed a violation. So be careful with that.
Didn't I say, panel, before we went on that John knows everything about the law? Honestly, I did say that, right? That's
not true.
Okay, not true. All right, don't take credit for it. Okay, let's do really quick last call. Very quickly. Let's start with Deb. Any comments on anything that went on today or anything?
I think this was a good session. I think what you're going to hear from most people is you got to utilize your professionals because that's who has the information that's going to make the best decisions.
Cory.
Great webinar. Usually we're tasked with keeping secrets rather than exposing them. And so that was fun today.
Elliot.
I'd just say we've talked about challenging owners, and there are legitimately like crazy people out there, but I always try to remind myself we are dealing with people's houses, and we just need to keep that in mind when we're dealing with people who we perceive to be difficult.
Now you're making me feel bad again. All right, Dawn.
Yeah, I think that secrets is a great topic because when we bring things into the light, it really gives people different perspectives. And so these discussions, if we continue to have them, I think they take away the uncomfortable feeling that some people get from that.
Kevin.
Ray, I just can't thank you enough for all the valuable comments that you provided today. But I will. I thought this was a great session. It was very illuminating. If you're kind of on the other side, to avoid a lot of issues, and it kind of boils down to, for the insurance people, doing things as a practical matter that are going to prevent claims. And some of it's common sense, some of it's just consulting with your professionals. And if you do that, 80-90% of the time, you're going to be okay.
Kevin, I've been asking for an honorary law degree from Adam Clarkson for years. Will you give me one? Am I good enough yet?
Ray, I understand your comments, but I'm going to have to get back to you after the live stream.
All right. John.
No, I'm not going to give you an honorary.
I know that. You already told me no.
That's why John knows everything.
John's been around for so long. Okay. Stacey.
I think it's a great topic that can be done over and over again because different issues arise all the time and we know all the secrets. So it's definitely something we should do again.
Now, for those of you, you can see Dawn and I again. We're going to be back at 1:40. John, Kevin, Cory, Deb, Elliot, Stacey, will I see you in the audience at least? Be honest.
I'm gonna be taking my nap, Ray. So you caught me. That was my other secret.
I appreciate everybody being here as always. Thank you so much. Audience, I love it. You guys with the comments, it's such a huge help. Bye, everybody. And I will see some of you back later. Thanks for being here.
Bye, guys.